I call Keith Locke.
Thank you, Mr. Chairman. I appreciate the Minister answering some of the questions that have been raised. I think that's very good. It's true that this Act, the 1958, has been amended, but I think this, from what I can gather, this Section 57 has not been particularly amended, only in a very minor way, and certainly not in the substantive piece that she referred to. It's true that the 1958 Act talks about holding particulars unless the person is acquitted under 57(3), but it is also true that under the second bit of that particular clause, it talks about other people it uses the word, it doesn't apply if a person is acquitted on account of his insanity or is discharged under and something else. So the qualification to that 57(3) uses the word discharged, and in fact it's interesting that when you go to the Children and Young Persons and their Families Act 1989 283A, it talks about for people who are not the concept that those young people are not convicted if they come under one of these provisions, and the first one is that if the court discharges the young person from the proceedings without further order or penalty, and again uses the same wording, discharge, to accept the person from the identifying particulars, the same wording that is used to make the person not apply under 57(3) of the original 1958 Act. And but all that being said, I think the question is, and I think the Minister has now admitted it really, that you can have doubts around all of this and what the meaning of legislation and what the intention was, etc., etc. But certainly in terms of what was explicitly stated during the parliamentary debate or in any of the documentation that the government put out around that debate, there was nothing that nails the interpretation of the legislation in 2008 to what the Labour Party or the National Party is saying now. And in that context, and in the context of you're not going to have a whole lot of young people who've got through the court system suddenly jumping up and wanting to be brought back into the spotlight with appeals. So the problem is not there really for the government or society if we consider this in a more considered manner than rushing this whole thing through Parliament under urgency. And so we do appeal to the government at this late stage to change their course and say, well, let's have a longer period to deal with this. We've got time. We can do it. Don't just push it through today under urgency. Thanks.
The Honourable Enoch King.